Subject: Law of Criminal Procedure. Topic: The Pillars of Procedural Justice, Adversarial System, and Constitutional Safeguards. Namaste, everyone, and welcome. We're diving right into our series on the law of criminal procedure in India, specifically looking through the lens of the new Bharatiya Nagarik Suraksha Sanhita, 2023, or as we're going to call it to keep things simple, the BNSS.
Here's the agenda for today's explainer. We've got 4 main parts. Number 1, adversarial versus inquisitorial systems. Number 2, constitutional safeguards. Number 3, an introduction to the BNSS 2023. And number 4, a quick summary. Whether you're a law student, an aspiring officer of the court, or just a curious citizen wanting to know how justice is actually administered, this explainer is built to walk you right through the procedural machinery of criminal law, step by step. Let's kick things off by asking a really fundamental question. When a crime is committed, how exactly does the state determine guilt and deliver justice?
All right, part 1, adversarial system versus inquisitorial system. Broadly speaking, these are the 2 main systems of criminal justice that you'll see followed across the world. So in India, we follow what's known as the adversarial system. You can kind of think of a criminal trial here like a structured contest between 2 opposing sides. In one corner, we have the prosecution, representing the state and the victim. In the opposite corner, we have the defense, fighting for the accused. And the judge? Well, the judge essentially acts as a neutral umpire. They don't go out to investigate or gather evidence themselves. Instead, they sit back, listen to the arguments, test the evidence presented by both sides, and then make a decision strictly based on what is actually proven right there in the courtroom.
Now, an absolute cornerstone of our adversarial system is the presumption of innocence. You've probably heard this before. Every single accused person is presumed innocent until they are proven guilty. So who has to do the proving? The burden of proof lies entirely on the prosecution, and they can't just prove it's likely the person did it. They have to prove the guilt of the accused beyond a reasonable doubt. If there is any reasonable doubt left hanging in the air, the benefit of that doubt must go to the accused.
Let's quickly contrast this with the inquisitorial system, which is a setup you'll find in civil law countries like France and Germany. Over there, the judge is definitely not a passive umpire. The judge actively directs the investigation, gathers evidence, and questions the witnesses. There really isn't a separate, fully independent police investigation to the extent that we have here. Now, while that inquisitorial system is incredibly efficient at finding facts, our adversarial system provides far stronger protections for the rights of the individual. That said, under Section 165 of the Bharatiya Nagarik Suraksha Sanhita and Section 313 of the BNSS, our Indian judges do actually have some active powers. They can summon witnesses or ask questions if they need to, but the core structure, that remains strictly adversarial. Moving on to Part 2, constitutional safeguards. It's absolutely crucial to remember that our procedural criminal law must always comply with the Constitution to protect an accused person in India. The first major pillar here is Article 14, the right to equality before the law. Basically, this guarantees that the rules of criminal procedure apply equally to everyone, completely free from any arbitrary discrimination. The second pillar is Article 20, and this one packs in 3 very specific protections. First up, Article 20, Clause 1, prohibits ex post facto laws. What that means is you cannot be convicted of an offense unless the act was already a crime under the law at the exact time you committed it. No backtracking. Second, Article 20, Clause 2 protects you against double jeopardy, so no person can be prosecuted and punished for the very same offense more than once. And third, Article 20, Clause 3 protects against self-incrimination. You cannot be compelled to be a witness against yourself. And as the Supreme Court laid out in the landmark case of Nandini Sapathy versus P.L. Dani, this protection extends even to police interrogations. An accused has the full right to remain silent when asked questions that could expose them to criminal liability.
Now for the third, and honestly perhaps the most vital pillar of all, Article 21. This is your right to life and personal liberty. Under Article 21, no person can be deprived of their liberty except according to a procedure established by law. But here's the real game changer. In the famous Maneka Gandhi case back in 1978, the Supreme Court established that this procedure can't just be any random procedure. It must be just, fair, and reasonable. It's actually from Article 21 that we derive the right to a speedy trial, which was highlighted in Huzaimara Khatun versus State of Bihar, as well as the fundamental right to free legal aid.
Rounding out our constitutional safeguards, we have Article 22, which is your shield against arbitrary arrest and detention. Under Article 22, every arrested person has the right to know the exact grounds of their arrest, the right to consult and be defended by a lawyer of their own choice, and the right to be produced before the nearest judicial magistrate within 24 hours of being arrested.
All right, Part 3, Introduction to the BNSS 2023. You see, all these constitutional safeguards aren't just theoretical. They are directly codified right into the sections of the BNSS to protect your individual liberty. Let's explore exactly what this new code entails. This brings us to the BNSS itself. The Bharatiya Nagarik Suraksha Sanhita 2023 officially replaced our old Code of Criminal Procedure from 1973, and it officially came into force on the 1st of July 2024. Now, while it retains the core structure of the old code, it brings in some much-needed modern reforms. We're talking about specific timelines for trials to keep things moving. It integrates everyday technology, allowing for things like electronic summons and mandatory audio-video recording of search and seizure operations. Plus, it places a much stronger focus on victim rights. And finally, Part 4, Summary. We've covered a lot of crucial ground today, so let's synthesize the whole shebang. In summary, we've learned today that India follows the adversarial system of justice, where the prosecution has to prove guilt beyond a reasonable doubt before a neutral judge. We also examined the powerful constitutional pillars under Articles 14, 20, 21, and 22 that guard the rights of the accused at literally every step of the criminal process. But all of this brings up a really important question, one that leaves us with plenty to explore next time. In the system, who exactly hands down the punishments? In our next explainer, we are going to climb the judicial ladder. We'll explore the entire hierarchy of criminal courts in India, from the magistrates up to the high courts, and understand exactly what sentencing powers each court holds. Thank you so much for joining me. Keep learning, and I'll see you in the next explainer.